Hello and welcome. You're watching Breaking Views. I'm Nidhi Razdan. First there was the Ram Mandir. Now Hindu groups are stepping up pressure to lay claim to other religious sites where mosques currently stand. Today, a Varanasi court ordered a pond inside the Gyanvapi Mosque in Varanasi to be sealed after Hindu petitioners claimed that a court-ordered survey had found that it contained a well with a Shivling in it. The water body is otherwise used by Muslim worshippers for a purification ritual before prayers. All eyes are now on what happens tomorrow because there is a Supreme Court hearing as well in which the petitioners are demanding a stay on this survey of the Gyanvapi Mosque. They are saying that it violates the law. There is a 1991 Places of Worship Act which basically says status quo needs to be maintained at all religious sites as they existed on 15th August 1947, and this was upheld by the Supreme Court itself in its 2019 judgment on Ayodhya. The only exception to that legislation was the Ram Janmabhoomi site. Now, let's take a look at the Gyanvapi Mosque complex and what exactly the dispute is about. Now, this is the complex of the Kashi Vishwanath Mandir and the Gyanvapi Mosque, which are actually side by side. As it zooms in, we're going to show you where the Prime Minister actually recently performed a puja in the newly renovated Kashi Vishwanath corridor. This is where Mr. Modi had performed that puja very recently. And right next to that is the masjid. You can see the wall that separates the two. Now, Hindu groups say that where the masjid is where a temple used to be and that this was destroyed on the orders of Emperor Aurangzeb in 1699. You can see there's a water body there in that masjid complex. That is the pond, and this is where Hindu groups claim that a Shivling lies beneath in a well. However, Muslim worshippers say that this is a fountain. There is no Shivling here, and this is the pond that has now been sealed by the court in Varanasi today. So no one has access to it. Hindu groups also claim that under the domes that you see of the mosque lie the idols of Hindu deities. In the petition before the Varanasi court, there are 5 Hindu women who've actually sought round-the-year access to pray at the shrine behind the mosque complex. That site is currently open for Hindu prayers once a year. They're saying that we'd like to keep it open all year. Well, joining us on NDTV now is Mr. Asaduddin Owaisi, Lok Sabha Member of Parliament, on this developing story today. Mr. Owaisi, your thoughts on the day that this pond has been ordered to be sealed with the Hindu groups claiming that a Shivling has been found there. There are bigger implications, in terms of where all of this is headed, aren't there?
Yes, these apprehensions were voiced by me when the Babri Masjid title suit judgment was given. I had at that point of time on record said that this will open many doors, and because that judgment had given on the basis of Astha. Now, despite Supreme Court elevating the 91 Act to the level of basic structure of the Constitution, today's order completely violates the 91 Act. This order of today of sealing that area and allowing only 20 people to do namaz over there is a blatant violation of 91 Act, which changes the nature and character. And you're absolutely right. Tomorrow it will be Qutub Minar, tomorrow it would be Taj Mahal, tomorrow it would be Mathura. I don't know. The Sangh Parivar has a list of more than 50,000 masjids. So there is no end to this nonsense. And the question over is that how can a lower court go against a Parliament Act? How can the lower court violate the Supreme Court judgment? And I hope that tomorrow when Supreme Court hears this matter, I don't know what Supreme Court would do, but we have to wait and see. But as of now, this is a complete violation. This is the repeat of what happened to the Muslims in 1948 December, and this will continue to happen.
I wanted you to elaborate on the Places of Worship Act, Mr. Owaisi, and why this act was brought in the first place. As you rightly said, it is there in law, and yet you have this lower court order which goes completely against that. So the Supreme Court's verdict on this is going to be very crucial. But why is it important? Why is the Places of Worship Act important?
Because in 1991 it was decided that apart from Babri Masjid, that every religious place which stood on 15th August 1947, the nature and character of that particular religious place would not be changed. Keeping in mind all these issues. And in fact, if you read even the Supreme Court judgment, the Supreme Court of the judgment quoted the statement of the then Home Minister to maintain the integrity of the country, to maintain peace. That is what the then Home Minister in 91 stated. Now, today's order is complete violation of that. And my biggest apprehension is that it will not stop the RSS and the BJP. They will continue to find ways and means of changing the character of all masjids. So unfortunately, this will continue. And my biggest fear is that as a teenager, I have bad memories of what happened post-demolition and pre-demolition. Now you are giving this same bad memories, unfortunately, if it happens to this millennial generation. So we have been deceived once. Now I hope I'm wrong. We'll be deceived again second time around.
But Mr. Owaisi, there are those who would argue that the difference between the Babri Masjid case and this particular matter is that here, at the moment, nobody is saying that, bring the masjid down and build a temple on top of it. They're saying we want access all year to be able to do our puja, to do our prayers. You're shaking your head. You're saying that, no, that's not, there's no difference.
See, I'll tell you, Section 4.2 of the 91 Act clearly states that nature and character should not be changed. Why I'm shaking my head is that this is a complete textbook style of what happened when Babri Masjid was taken away from Muslims. The idols were placed surreptitiously. The masjid was closed. Now you see that one part of the masjid is closed. And tomorrow you will see that the puja will be allowed. Thirdly, one fine day, politically this will become a big issue. And we never know, again a demolition of this masjid can happen. So now tomorrow, even when the Supreme Court is going to hear this matter, I as a Muslim, I don't know what should I ask the Supreme Court. I hope that the lawyers who are more knowledgeable than me, my dear friend Fusail Ayubi, because you will have to ask for a stay of this present order and to ensure that the 91 order is not violated. See, this whole thing is done in a very, very sophisticated way, because tomorrow Supreme Court is going to hear this matter. Suddenly you say that this thing has been done. You seal that area and you say that, oh, you cannot go and pray over there. So I have been bitten not once. This is going to be more, the biggest unfortunate part would be that this is not going to stop. There are many masjids which will now be reopened and on the basis of Astha.
So finally, what would your appeal be ahead of the Supreme Court hearing? Then everything centers around what the top court decides to do in this.
I hope that the Supreme Court itself, when they wrote the judgment of Babri Masjid, they said that the 91 Act is related to the basic structure of the Constitution. This is what our main demand is. This is what the honorable judges have written in that judgment. But today's development is a very, very clever way of ensuring that, oh, we have sealed that area now. You cannot come over there. Only 20 people will be allowed. So tomorrow, and please remember, Nidhi, the magistrate who stopped the Muslims from praying in Babri Masjid 1948, Mr. Nayyar, then went on to become a member of parliament from Jan Sangh. When the locks were opened for the Babri Masjid, the honorable judge wrote in his book. Now, this is what has happened. That is why I have been consistently voicing at the cost of people saying you're provoking. I'm not provoking. I am forewarning the whole country that please don't take us back into that dark era of pre-demolition of Babri Masjid. And please, for God's sake, uphold the law. Follow the Supreme Court judgment. There is no into this nonsense. You want to go into the beneath of what Taj Mahal is there. You want to find out what is there at Qutub Minar. You want to stop at, you don't want to stop at Mathura, but this is what is going to happen. And all these people are ably supported by the BJP and the Sangh Parivar, that no one can deny that.
Well, Mr. Owaisi, all eyes on the Supreme Court then, whether the court upholds a law that the parliament has passed and what the court itself has said, as you rightly pointed out in the Babri Masjid case. Thank you for joining us today. Well, joining us now on Breaking Views, Abhay Nath Yadav, who's the advocate for the Mosque Committee and fighting in this case in the Varanasi court. With him is Madan Mohan Yadav, who represents the Hindu petitioners in the Varanasi court, and two Supreme Court advocates joining us this evening. Shadhan Farasat is with us, as well as Mr. Ashutosh Srivastav. Thank you all for being with us. Madan Mohan Yadav ji, सबसे पहले मैं आपसे पूछना चाहूंगी, the case that you are pursuing, एक तरफ आपका केस है जो अब आज कोर्ट ने इस पे एक बयान दिया है, लेकिन दूसरी तरफ ये जो प्लेसेस ऑफ वर्शिप एक्ट है वो भी एक सच्चाई है, वो हमारे पार्लियामेंट ने पास किया है. हाउ इज योर केस नॉट वायलेटिंग दिस एक्ट? I think we've lost that link to Mr. Madan Mohan Yadav. Let me take that question to Shadan Farasat straight away. Shadan, all eyes, as I said, on the Supreme Court on this matter. But, in these times, one just doesn't know which way this could go, even if it's laid down in the law.
Yeah, no, that's true. I mean, we live in crazy times, if I can, for lack of a better word. So while it's impossible to predict anything, including how the court decisions will be, despite the own judgments, I think I just want to flag 2-3 things. First, this is the third attempt at the Gyanvapi Mosque. The first suit was filed in 91-92. It was after the Places of Worship Act was enacted in September of 91. It was dismissed as non-maintainable in 1998. Because of the Places of Worship Act. The second attempt was made in 2021 and it was stayed by the Allahabad High Court. Now this is the third attempt where a fresh bunch of 5 women have come, and in this order, similar orders were sought in 2021, some kind of a survey, etc., and that was stayed by Allahabad High Court with observations that the order of the lower court was an act of grave judicial indiscipline. Now, this third attempt has been carried out this time. And of course, as of today, there is some kind of a survey. Somebody has found something. And, this is the third attempt. It's clearly in the face of Places of Worship Act, because see, what's the principle there? The principle in Places of Worship Act is we have a country with a long history. We have layers and layers of history. Now, post 1947, 15th August, if we are to try to dig over that history, and literally that's what is being sought to be done here, you are going to only create conflict in today's society. It is not just in the context of Hindus versus Muslims. It could be in other contexts also. You could have Buddhist temples and Buddhist shrines, which have been thereafter. There is enough documented material that Buddhist shrines and Buddhist temples were then converted into Vaishnava or Shaivite shrines. Now, are petitions going to be filed for that kind of stuff to reclaim it 3,000 years ago, what it was? So it can't be. So that's the logic of the act, that post 1947, 15th August, we have a country which is diverse, we have a history, and we look to the future. That's the principle of this act. And therefore, we are not going to contest ghosts of the past, as it were. Now, based on that principle, the Supreme Court, while passing the 2019 Ayodhya Babri Masjid judgment, has not just accepted that act. I'll just read out one para. You give me 30 seconds. Yeah. And what it says. Para 997, it's very useful. This court cannot entertain claims that stem from the actions of Mughal rulers against Hindu places of worship in a court of law today. For any person who seeks solace or recourse against the actions of any number of ancient rulers, the law is not the answer. Our history is replete with actions that have been judged to be morally incorrect and even today are liable to trigger vociferous ideological debate. However, the adoption of the constitution marks a watershed moment where we, the people of India, departed from the determination of rights and liabilities on the basis of our ideology or religion, the color of our skin, or the century when our ancestors arrived at this land and submitted to the rule of law. So tomorrow before the Supreme Court, these very words of the Supreme Court are going to be tested.
Yeah, exactly.
Because if we are in a country of
these are the
if we are in a country of rule of law, then not just the trial, and in my, I speak as a layman, but even the order today needs to be stayed. I mean, what was the rush for the trial court to proceed in 3 days?
Let me get Ashutosh Srivastav in on that. Mr. Srivastav, do you agree with that, or is there any other way to look at this except as something being in direct contradiction of the Places of Worship Act?
See, I don't agree what my learned friend said for the reason that there are basically 3 exceptions, major exceptions or exemptions as far as Places of Worship Act 1991 is concerned. Now, the first thing is that the places which have achieved the characteristic of a religious place till from the date 15th August 1947, those places only can be considered to be the places of worship as per the Act of 1991. Now, the exceptions are, the first exception is that if the characteristic of a place has changed after 15th August 1947, then the act of this 1991 Places of Worship Act will not apply. Then the second one is that is the second exception, that if the places are covered, the ancient monuments are covered under the provisions of the Ancient Monuments and Archaeological Sites and Remains Act 1958, then in that case also the provisions of Places of Worship Act 1991 will not apply. The condition is that the place should be 100 years or more older, being the ancient monument. The third exception is that if there is a settlement between two parties, then the Act of 1991 will not apply. So obviously in this case, the third exception is not applicable. But so far as the first two exceptions are concerned, obviously the court has rightly ordered for the survey. The court has not ordered anything that whatever was constructed, whatever was not constructed. The court has gone by taking the exception. Now suppose if the place of worship was changed after 15th August 1947, that has to be checked, that has to be analyzed, that has to be surveyed by the...
But I just want to know where that claim that it was changed after 15th August 1947 has come from. Because the claim is that it was changed in 1699 by Aurangzeb.
Now if I say that this place was used as a temple or whatever 100 years prior, then this act will not apply. The provisions of this act will not apply. So now, unless and until the report comes, the court has asked for the report. The court has not passed any judgment as such. Now, when the report comes, then only it can be decided. Now, this order was challenged.
Before I get the advocates who've been arguing in court on this, Shadan, do you just want to, you were raising your hand on this. I mean, I might be wrong, but my understanding was that basically the Places of Worship Act says, if on 15th August 1947 a mosque stood at X place, it's going to remain a mosque. If it was a temple at X place, it will remain a temple, right? Unless I've misunderstood.
No, that's correct. If it's a mosque, it's a mosque. If it's a temple, it's a temple. Gurdwara stays a Gurdwara. What my friend is referring to is if there is an exception in section 4. That is, if something is an ancient monument, that is in effect, if something is an ancient monument, that is a mosque or a temple or anything of extreme importance, and if prayers in that place were to be carried out, which will destroy the place. You see, if something is, if people visit every day, then for that purpose alone, that's the intent of that provision. There is an exception for ancient monuments that you can stop that place from being a place of worship, but that cannot still mean that you will change the nature of that place of worship.
Okay. Let me get the advocates who've been arguing this in Banaras to come on. Abhinath Yadav represents, as I said, the mosque committee. Mr. Yadav, let me ask you first. What is your expectation then from the Supreme Court? The fact is that, the Varanasi court has gone ahead. It let the survey go ahead. It has now taken the next step and ordered for this one area of the, of the mosque to be sealed. So they seem to be taking steps that are going in the favor of the Hindu petitioners here.
First of all, I am very much shocked that the district court has passed the order in the way. The case has been filed pending in report of Civil Justice Senior Division, and that court has issued the commission. The commission report has not been submitted before the court till date. What was the evidence available before the court that there is a Lingas of Lord Shiva, and the court has passed the order. This order is highly absolutely illegal unless and until the report is submitted before the court by the working commissioner. No such order can be passed. I am agreed with my brother who is interpreting the Places of Worship Act. If such order has been passed, it is totally against the Places of Worship Act, because the very preamble says that there should not be any conversation of any religious place. Religious place may not be confused with the religious structure. What is religious place means what type of religious performance of any religion is going to perform in that particular place. Here, in so far as the Gyanvapi Mosque is concerned, undoubtedly a regular namaz is being offered since several centuries, since last century. and no such performance as puja or any Hindu religion is being done in that tribunal. This order is absolutely against the places of the religious sect. And moreover, the para 997 of the Hindu Ram Janambhoomi Masjid has been quoted. That is very correct, because in Ram Janambhoomi it has also been, there is a verdict of the Honorable Supreme Court that the past wrongs cannot be corrected by a law. This order is highly absolutely legislative. Itself will be violation of the public places of worship.
Yeah, exactly what we were talking about. Madan Mohan Yadav ji, you represent the Hindu petitioners in this case. According to you, how is this petition not in violation of the Places of Worship Act? I think we're having repeated trouble getting through to Mr. Madan Mohan Yadav, so I don't think I'm going to try and make a third attempt. But let me ask Mr. Ashutosh Srivastav this. Just on a larger point, where do we stop? Where do we stop, as far as digging the past is concerned? I mean, as Shraddhan Farasat rightly said, we are a country with a history that goes back hundreds, thousands of years. There are layers upon layers. If you keep digging, you'll keep finding something. There are places today where temples stand, where mosques once stood, and vice versa. So are we sort of not creating a problem for our present and our future by constantly going back to this?
See, that's a different issue. See, every citizen of this country has the constitutional right to go and challenge and to safeguard its own constitutional right. If somebody, as a citizen of this country, feels that his or her constitutional right has been violated, he can go. We cannot stop anybody from approaching the court. Now the court has to obviously work on the principles of law. Now, so far as this matter is concerned, as my friend finally agreed, that there are exceptions so far as Places of Worship Act 1991 is concerned. Now the court has to see whether this falls under any exception or not. And this can only be ascertained with the proper investigation or the survey of the issue. And unless and until it is surveyed and the report is submitted, whether it comes under the Ancient Monuments Act 1958 or not, whether the place, the characteristic has changed after 15 August 1947 or not, these are all the issues which have to be determined. The Supreme Court has nowhere changed the very existing law of Places of Worship Act 1991. The provisions are still intact, and whatever the court has ordered for the survey is based on the same law. It has not changed, it has not violated any law. And the same order was challenged before the Allahabad High Court bench, which also rejected the appeal. Now it has gone finally to the Supreme Court. Obviously, the Supreme Court has to see whether the court's order is as per the existing law or it is not at par with the law. That is what has to be seen. Now, if somebody says how far it will go and all, so that is a different issue. We cannot stop, the law cannot stop anybody from approaching the court unless and until that petition is completely against the principles of law. Now, so far as this matter is concerned, obviously this matter I think was filed long years back in 1991 somewhere, and till the court has followed the procedures of law, and accordingly this order of survey has been passed. It is not, and see, as far as the prayers or namaz is concerned, that has never been disturbed by the court. That is within the premises of the mosque. Now, what is the issue involved is the pond, where they claim that a Shivling has been discovered or whatever. Now, that can only be ascertained by the impartial report which is going to be submitted. Now, that report, the court will, whether it considers that report or not, that is again a different issue. Now, so far as
yes, but my point is, Mr. Srivastav, that can happen then at multiple sites. Today it is Gyanvapi, tomorrow it will be elsewhere, and there'll be, yes, everyone will say that, oh, there's a Shivling here, or there is the remnants of a mosque there, because that is what our history is. So yes, how is it not a violation? I mean, there's a reason the Places of Worship Act was put in place, right? Exactly for this reason.
Absolutely. The court has not passed the report of survey in a day or two. Obviously, if there are prima facie evidences which clarifies that position, In that extreme cases, only the court would go to that level, considering and
But my point is, you would find that Shadhan Farasan, correct me if I'm wrong, you would find evidence of XYZ structure at so many different sites that exist today, right?
Evidence is completely irrelevant. Yeah,
exactly.
Right. So evidence is completely irrelevant to the scheme, the constitutional scheme, as also the Places of Worship Act, because it's based on the assumption that we've had layers of history. And therefore, there could be in Madhya Pradesh, there are so many shrines which were Buddhist shrines. Now they have ceased to exist. Today there are in fact claims of there being Hindu temples on what were earlier Buddhist shrines. Are you going to dig all of them? Of course not. So that's the principle behind the Places of Worship Act. And you can't, if you're going to artificially stop, you don't begin with the Mughal era. Then you begin with 4,000 years and let's unburden the entire history. Are you going to do that? Of course not. Because if you're going to do that, you're going to destroy the present society we live in. We are only going to be fighting each other of what our history 4,000 years back was. And that's not the constitutional project. The constitutional project is that whatever our history is, we now look forward and live together.
Well, clearly, we have to live in the past. Such are the times we live in. Let's see what happens in the Supreme Court tomorrow. All eyes on whether they will uphold their own ruling at the end of the day, as Shadhan Farasan pointed out. Thank you very much to all of you for joining us on Breaking Views tonight.